Okay, welcome. I'm Bill Norman. I'm a partner at Norman and Zak in Santa Monica. I'm here with my two co-panelists, Stephen Mihaly at KFB Rice LLP, and it's a Los Angeles law firm, and Howard Fisher, who's a partner at Fisher & Fisher in Beverly Hills. Our topic today is the new final regulations on reporting of beneficial ownership. It came out in September 29th or 28th, depending on when you got your Federal Register. It basically deals with reporting of ownership of closely held legal entities. It applies both to entities that are in existence and ones that are going to be ones that will be formed in the future. The general effective date is January 1, 2024. Let me move to the next slide. Here's a little review of our agenda. I mean, basically, we're going to talk about who's required to report, what they're required to report, when, what's in the report, what happens to the reports themselves, and what happens to somebody who is responsible for filing a report but doesn't file a report. And then we'll talk about some planning for practitioners to deal with this new requirement that is quite broad in scope, and also talk about what's up in the future. The bios of the panelists are in the back of the slide deck for more detail. For the next slide. Here's just a nutshell of what the basic rule is. The reporting company is required to report to FinCEN, which is an agency of the U.S. Treasury dealing with criminal enforcement. The report is to identify so-called beneficial owners of the entity, which includes not only actual owners, which is the 25% level, but also those that exercise substantial control, which is defined in some detail in the regulations. Also, so-called company applicants who filed or directed the filing of the organizational documents for the entity, or if it's a foreign entity, the registration of the entity with a Secretary of State or a similar office in a state. For the next slide. This is just a background of the legislative history, not the complete history, because Howard will talk about a little bit more about what was a precursor of this National Defense Authorization Act, which is the kind of vehicle for this particular legislation. But we're coming down now to the final regulations. The slide says September 30. I actually got them September 29th, but that's irrelevant unless you're looking for the Federal Register site. You may have to use the appropriate date here. The important document here is the statute itself, which is I have the USC site up there, US Code site for the portion of the act. It's in the National Defense Authorization Act. The final regulations are just 9 pages in the Federal Register. They get spread out quite a bit if you have a regular type version of it. And there's some 91 pages in the Federal Register, a preamble. So the regs have the final regs have this kind of 10 times the amount of verbiage that explains what the regulations are about. They are important in terms of interpretation. What the draft of the regulations declined to include in the regulations, and why they included certain things. So it does have some helpful explanations of the regulations, but the regulations themselves are relatively short and concise. So the next slide here. This is just the public policy. The original proposed regulation said that the regulations are intended to protect national security, provide critical information to law enforcement, promote financial transparency, and to prevent so-called malign actors from obfuscating their activities through the use of anonymous shell and front companies. The regulations themselves seem to cover a very broad scope of companies, which probably are not involved in the activities that are described here. With that, let me move this to Howard, who's going to talk a little bit more about the kind of precursor of this kind of legislation.
Sure. Thank you, Bill. You know, part of the purpose of all this, although they say is national security, we want to be able to enforce the Ukraine sanctions, and we want to go after drug traffickers and fraudsters. How many of these folks do you think are going to end up actually filing these, or will find another way to invest in the U.S.? For example, if you have a foreign company and you're investing in the U.S., but you're not involved in an active U.S. business, you don't have to report. So this is going to be much to do about nothing. Maybe in the end, it's going to be like the Al Capone laws, that they're going to be used to jail the bad guys when they can't get them on anything else. And unfortunately, in between, it's going to pick up a lot of us good people who just make a mistake and fail to file. Beginning in the early 70s, we had the first reporting obligations, initially under the money laundering rules, the Bank Secrecy Act. And shortly after that, by the end of the 70s, there were forms like the benchmark survey by the Department of Commerce and the FIDA reports, the Department of Agriculture, that wanted to know about foreigners investing in the United States and foreigners investing in agricultural products. The EU has, for almost 2 decades now, been very active in trying to figure out who owns various entities and imposes great obligations on lawyers and accountants. And those obligations override the attorney-client privilege. So if a client tells you that they have nefarious thoughts in mind, you're going to have to report them if you're part of the EU. We haven't gone that far here in the United States yet. You might take a look at the 2016 geographical targeting orders, which came out of FinCEN. And they were a series of reporting obligations of beneficial ownership of entities that were involved in real estate transactions in certain counties. It was Broward in Florida, New York, and a couple of others. And what quickly happened is people with bad intent, people who wanted to just pile money in U.S. assets, didn't go to those jurisdictions. They went elsewhere. And that's what's going to ultimately end up happening here as well. The UK back in 2016 started a registry similar to what this Transparency Act does, except the British version is available to the general public. And so anybody could look up individual corporate ownership. Okay. Why is any of this important to us? Well, there's, we'll be talking about later, some very substantial penalties and potential criminal penalties that could be imposed for failure to file. And this, the filing requirement extends to all existing legal entities that are still around as to the ownership and control. Newly formed entities are going to have a very short window to report. And there's an obligation to correct or update all information. And again, it's a very small window to make corrections or updates. So in terms of existing clients, no, you don't have to go back and look through all the companies you formed for several hundred years. Bill will talk a little more about this, but it might be a good idea to reach out to your older clients. And also at that point, remind them of obligations like annual minutes and maybe get them back on the path of doing those things. For all the newer entities you organize, you're going to have to get into this reporting mode and explain it to your clients. Most of us have a form cover letter we send out when we organize a company. We need to have an explanation about this in it as well. Who has to report? It's a domestic reporting company and a foreign reporting company. What's a domestic reporting company? And the key is entities that come into existence upon filing with the Secretary of State some type of document. And the new rules make it clear that the feds are going to be looking at state law to make this determination, not federal law, which is helpful. It obviously includes corporations, LLCs, does not include, apparently, partnerships or trust, but does include LLPs and LLLPs. And the reason I say it doesn't include trust is almost no trusts are formed by registration with the Secretary of State. In a few states where you have business trusts that can register, those will probably come under the new rules. And a foreign reporting company is corporations, limited liabilities, and other similar entities, which is the same concept as state law, as a domestic, but again, we don't know what other similars are. And the key is it has to register to do business. It's registered rather to do business in any state by filing a document with the Secretary of State. Now, what's interesting is it doesn't say an entity that is required to. So what if you're required and you don't file? Are you a foreign reporting company? Not clear. Steve and Bill, do you have any thoughts on that one?
I would think they'd interpret it to mean if you're supposed to file a register, you're supposed to report.
But let's say you simply don't, and then not a real stretch. You have an LLC and you're a foreign company, and you're a member of an LLC, foreign LLC that's doing business in California, and you forget to qualify.
Yeah, I think it's intended to be a bright line. So if you don't register, I don't think you're required to report. Although you do have a problem now with the Secretary of State, and if you're trying to bring lawsuits and in the state, you're supposed to register. So yeah, I don't, because there could be questions as you mentioned where it's unclear whether you're doing business or not.
Right.
It's not. The test is whether or not you're doing business determines whether or not you have to qualify. But if you simply don't qualify for whatever reason, or you pass that bright line test from being passive, having made a loan into California, and then becoming active.
It also inequitable that in certain states you're required to register, in others you're not. Like Florida, you may not have to register an entity if it owns a residence, let's say.
There's a large laundry list of 23 plus entities that are exempt from this obligation. Almost all of them have one overarching principle, and that is they're heavily regulated and there's a lot of reporting. So banks, credit unions, money depositories, money exchanges, commodity exchanges are all exempt. Things that you and I are more likely to run across may be a broker-dealer or somebody who's licensed as an investment advisor or an insurance company. Interestingly, tax-exempt entities are exempt. If Bruce Gisner is listening, one of the kings of VEBAs, 501c9, VEBA would be tax-exempt. I'm not tax-exempt. It's a tax-exempt entity that would probably be exempt from these reportings.
Can we move the slide along?
Oh, sorry. Oh.
I mean, one, Howard, we talked about before the program. Go back one.
Okay.
Right there, we get the list. Yeah, the public accounting firm. It's not all accounting firms would qualify for this exemption. Obviously, it's only those that are issuing audited reports, which according to the preamble is, I think it's 900 accounting firms out of some 130,000 accounting firms. So there's still a large number of accounting firms that would not qualify for this exemption. I'm not sure they'd want to just audit and go into the auditing business for the purpose of qualifying for this exemption. It's kind of interesting. The accounting firms and most accounting firms and law firms are not in this exemption category, because if you go back to that public policy purpose of malign actors using front companies, most of us don't regard our law firms or our accounting firms as being front companies for some illegal activity. But these exemptions are quite narrow, if you will, which means the coverage of the reporting is quite large.
Well, even with the tax exempt entity exemption, while the tax exempt entity doesn't have to report, if it owns a reporting company, an entity, then you look through the tax exempt entity and the beneficial owner has to file, and it is supposed to actually report the name of the intermediate tax exempt entity, but not all the other information. So the rules are very tricky and very broad in scope.
Maybe the next slide,
Yeah. So one of the main exemptions among the 23 exemptions is for so-called large operating companies. And there's basically 3 requirements in order to qualify as a large operating company and therefore be exempt from the reporting requirements. And one is that the company must have 20 full-time employees in the US, and full-time is defined under the Internal Revenue Code. The company must have an actual operating presence, i.e. a physical office in the US that it owns or leases, as opposed from just using space of another affiliated company. It must file a federal income tax return or information return in the US, which in the previous year must show at least 5 million of gross receipts or sales. There's special rules regarding how to treat foreign source income. So this is one of the primary exemptions from reporting, but you have to meet these 3 specific requirements.
Yeah, the definition of a full-time employee is fairly technical. I won't get into it right here, but there is a citation into the section 4980H.
Right.
Compensation or retirement plan section, and it's an average, and you do it by month, and so it's not all that. If you got somebody on the margin, you could have somebody who a company that kind of goes in and out of this meeting this 20 full-time employees.
Sorry, guys, I'm back.
Okay.
I don't know what happened. And unfortunately, I have to use my phone. So anyways, you need a physical office for the business. You can't use a personal residence. So you cannot be 100% virtual, which you would have thought they would have not required with all that's gone on in the last 2 years. And critically, you have to have shown at least 5 million in gross receipts or sales, domestic that is, in the previous year's tax return. So you can't qualify in the first year. You do an IPO, you raise $1 zillion, you get going in your first year, you have 500 employees in a big office, and you do $20 million in sales, doesn't matter, because you don't have a previous year return. So you can't qualify for the exemption. The second year of operations, or whenever you do qualify, you now have a change, and the change will require an updated report. And it's a fairly short fuse on updated reports. Inactive entities, there's the 6-factor test. It's going to apply to very few people because it has to be an entity in existence since 2020, have never had more than $1,000, and holds no assets.
Yeah, so this question, yeah. You can't have receive funds of $1,000 or more. And then it says not holding any kinds of assets. I'm not sure whether they can hold $1,000 in a bank account or any amount, or do you have to have a 0 bank account and no assets whatsoever? It's a little unclear in the regulations whether you're allowed $1,000 or at least $1,000 or less as an asset, which would be a bank account typically.
Yeah, I mean, but you're talking about you had to be in existence before 2020. So you're talking about pretty old entities. And yeah, we all have clients who have old LLCs. They formed, they never got going. Typically, they have not paid fees, so they're in arrears on fees. Cardinal rule that I've always followed, I know Bill and Steve always.
Howard, can you hear us? Looks like your equipment froze. Well, shall I continue, Bill, until Howard comes back, I guess? Anyway, the point of these exemptions, I think, is that they're kind of
followed as well. If ever there's a doubt about reporting.
Howard, can you hear me?
Yes, I can hear you.
You're going in and out. Your sound is dying and then comes back.
All right, why don't you pick up with when is reporting required, which is your section anyway.
Yeah. Okay. Well, we were finishing anyway. The point of these exemptions is basically that they're very broadly construed. You should consider that most of the time you're going to have to report. The exemptions are pretty limited, and basically the companies that are already reporting anyway.
I don't know if you could hear me.
Yes,
I use Spectrum, and they're reporting an outage in my area and won't be restored till 3.
Well, we can hear you now, Howard. You're back on. Okay, so when do you have to report? So any domestic entity that's in existence formed on or after January 1, 2014, i.e. any new entity that's going to be formed after January 1, on or after January 1, 2014, has to report within 30 days. So you don't have much time if you want to avoid penalties, which we'll get into later. And any foreign reporting entity that has to register to do business, qualify to do business, on or after January 1, 2024, also has 30 days. Now, the vast majority of companies are all obviously going to have been created prior to January 1, 2024. So whether it's domestic entity or a foreign entity, they have to file by January 1, 2025. So they basically give you more time to get all the information that you need to gather to report. January 1, 2025 is the deadline for all existing entities formed to register before January 1, 2024. There's 3 types of reports. The initial report I just mentioned. Then you also have to report updated reports after you filed an initial report, and those have to be filed within 30 days whenever there's any change in the initial report that was reported. So as Howard mentioned, like there could be situations where, like in the large operating company exemption, where the reporting company goes in and out of qualifying under the large operating exemption. And either way, whether it qualifies or falls into disqualification, it's got to report because there's a change in their status and they have to update the report within 30 days. Also, if a beneficial owner dies, then you have to report that event too, and who is the successor beneficial owner of the original beneficial owner. So you have to watch out for the updates too, because you are subject to the same penalties as with respect to the initial filing if you fail to file. And then finally, if you file something that's incorrect or has some incomplete or error in it, you basically have 30 days to correct an error if you know of the error or have reason to know of the error, which is a pretty broad standard. There is one kind of exemption from the 30-day rule, which is that you have 90 days, it's kind of a safe harbor 90-day rule to correct an error if you file within 90 days from the date you filed the initial report or the prior report that had the error. Okay, Howard, I think you're going to cover who are considered beneficial owners. Can you hear me, Howard? Oh, we've lost you, Howard. I don't know if you can hear us.
Howard, you're muted.
Oh, Howard, yes, you're muted. Can you hear us, Howard? I don't think he's hearing us.
Yep, I'm back.
Yeah, you're back. Howard,
Okay.
are you going to?
Yep. So beneficial owners, I think, is on page 29.
21. Slide 21.
Here we go. Okay. Their beneficial owner is at first easy. It's the individual who owns. That's what they're getting at. The concept is beneficial owner. That's the golden nugget. That's what the government wants to know, who these people really are. And their goal is to try and get to a live human being as opposed to another entity. So beneficial owner is somebody who is the individual or who indirectly or directly has either substantial control over the reporting company, over the entity, or who owns at least 25% of the ownership interest in the reporting company. Substantial control includes all your officers. So just merely being an officer, even if you have no power or authority, will be enough. And I've seen this situation before where you have a strong individual who appoints a weak CFO, for example. The officer, the principal officer, the president ends up taking all the money, doesn't pay over all the withholding that's due to the state and the feds, unemployment taxes, and next thing you know, they have personal liability. So this is not an unusual situation. So it's senior officers, it's anybody who has the ability to appoint or remove a majority of the board, and anybody who has substantial influence over decision-making of the company. And that's really very broad, because what's substantial influence over major decisions? It's the ability to do sales, leases, reorganization, make major expenditures, terminate lines of business, establish compensation for senior staff, and handling of significant contracts. So it's a broad group of people that come within the beneficial ownership. And indirect could be through board representation, through ownership or control over another entity, through financial arrangements. You know, years ago, it was not uncommon on loans where the lender would have a seat on the board or be able to control certain decisions. All of those kind of arrangements kind of get picked up. And the test is 25% ownership interest. It's not the classic percentage of what number of shares you own. And it could be the shares, it could be any kind of equity, it could be through a joint venture or through an LLC, convertible instruments, options are all treated as though they're exercised. So you have no ownership today, but you have rights to acquire a third of the company. They would be treated as though they were exercised. Straddles, puts, calls, all get picked up in this concept of 25% or greater ownership.
Yeah, so just to clarify, there are two ways you can be a beneficial owner. One is if you just have substantial control of the entity, even though you own no interest in the entity, or if you have an actual 25% or greater ownership interest, which also can be just by virtue of controlling indirectly the interest. So it's extremely broad, the definition of what is a beneficial owner. You can be owning some ownership interest, or control the ownership interest through intermediary entities, or you just simply control the board. You don't even own stock. Well, you can't control the board, but you're a senior officer. You know, you can be a treasurer and you own no shares, but you're still a beneficial owner. So that's a trap for the unwary, because those senior officers are liable for the penalties, which we'll get into later, for failure to file. So this is a very broad definition of beneficial owner, not what one normally would think of.
Okay. And there's several rules dealing with ownership through a trust. Mm-hmm. And a trustee is automatically considered somebody having the necessary control and ownership. A beneficiary, who is the sole recipient of the income, or who has the right to demand distributions and withdrawals. And the settlor, who has the right to revoke, would also come under these trust ownership rules. I think if you're going to do planning to circumvent this statute, which I frankly would not, I think the answer will lie in structures. That may be the best way to end up doing this. And there's a couple of exceptions to beneficial ownership. Minors are not, but parents or legal guardians are required to report, so somebody's getting reported. If you're not an officer and are merely an employee, then you won't have to report. If your interest is a future interest right of inheritance, you don't have to report. So I'm not sure how far that goes. What if it's a joint tenancy, but it's only for purposes of estate planning with no current right of ownership? You know, would that have to be reported? And a true creditor interest, again, is exempt from reporting. And it's going to be all those arrangements on the borders or fringes, not the traditional loan, that's going to be a problem.
I guess, Howard, I mentioned at this point that the preamble talks about, how much time it would take to prepare a report, and you've gone through some very, assuming you have a fact pattern that would cover some of these rules. It would take some time to go through a trust instrument. Maybe it was drafted 5 or 10 years ago, or even more, or to go through some complex corporate structure to see if, in fact, you meet these, or who is the beneficial owner, for instance. So it could be a lot of time involved in actually determining who a beneficial owner is.
Right, even though they say for the vast majority of persons that will only cost $85 to go through this exercise to figure out what needs to be reported and who needs to be reported. But there's going to be obviously a certain percentage who have very complex structures, and figuring out who has to report and what has to be reported is going to be time consuming. And this slide on page 28 indicates that when you're calculating the 25% ownership interest, it's on an undiluted basis with respect to the all the corporate equity or whatever. But the individual beneficial owner, you count the options as if they've been exercised. So that means you're much more likely to have 25%, even though you may have not exercised them yet. Same thing with the partnership with respect to profits interests. And it's not only voting power, but also value, the 25%. So the rules are tricky, and you can get caught up in a lot of ways when you might not otherwise think. And the attribution rules are very broad.
There's a question here, by the way, Jonathan. It says, what about a medical corporation? Are they exempt, or do they have to register? Well, medical corporations.
No exemption for a medical corporation, unless you're, was it 1201L, one of those multifaceted health providers. But no, all professional companies are going to have to report.
Here's your 23 exemptions. If you're not on the list, you're not exempt.
medical corporations are fronts, but you know, at least according to the FinCEN, they wanted to pick up information about these corporations. Anyway, go ahead. I'm sorry, go ahead.
Yeah, let's see. Maybe I pick it up from here. Let's see. Oh, company applicant. Howard.
Applicant.
Yeah.
I'm sorry, is that me?
Yeah, the benefit, besides the beneficial owner, who else has to report is the company applicant.
Well, the applicant, and this is what starts to scare us folks as lawyers, because under certain circumstances, the company applicant is required to do the reporting. And who are the company applicants? It's the individual who directs and directly files the documents and creates the reporting company. That's like you and me, it's the lawyer. And the individual who directs or controls the filing. So that's still me if I tell my assistant, please go and file, and he files the application or files the articles. However, we don't have to go back and report companies that are in existence or registered before January 2024. So originally, we were all worried that we were going to have to go back and look at our records from the start of our practice of law to determine which companies we were an applicant for. And this basically gives us a pass. And this, I think, is probably one of the best parts of the regulations, was this change.
Right. So now what do you have to report, assuming you're a beneficial owner or a company applicant? So the reporting company has to file basically 4 or 5 basic pieces of information: the name, any DBAs or trade names, the principal place of business, state of formation, their taxpayer ID number, or if you're a foreign entity, foreign tax ID number if you don't have an IRS 10. So it's pretty standard. Now, that's for the reporting entity. Then the beneficial owner has to report, of course, also. And for every individual, they have to give their name, their date of birth, their current residential address or business address if it's a company applicant, i.e. Whoever filed with the Secretary of State or commensurate authority. Notice they deleted the requirement that the tax residence address has to be reported. It's not, they deleted that. And you have to give a, quote, unique ID number identifying document with an image, meaning basically a passport or driver's license. You have to scan it and send it to them. They want a unexpired current photo of you. Of all beneficial owners. No financial details or other information are required though. So these basic items of information. That's the beneficial owner. That's the initial report. There's some special rules regarding what has to be reported for tax exempt entities, which I mentioned. They're basically exempt, but you do still have to report the entity if they're kind of a look through. The beneficial owner has control through a tax exempt entity of the reporting company, let's say. So that's basically some special rules. Also, if there's any change, as I mentioned, you have to update or a correction the initial report, of course, within 30 days. Let's see. So, yeah, Bill, I think you want to.
What I try to do here is to kind of summarize what we've just been talking about in the previous 33 slides, and to kind of put it into a simple outline of how you might approach reporting in your own office. The question, you should obviously expand this somewhat, but I'm trying to simplify it here. First step is really to identify, and we'll see some examples here, identify reporting companies, and take out the exempt companies. Determine the date of organization, because that's important as to what information is required and when the filing is to be done. Determine the beneficial ownership, which looks simple here, but the 25% undiluted voter value, and then substantial control and substantial influence, and some exceptions for minors and inherited situation. Then you have to identify the company applicants. And now that's just with respect to companies formed after the effective date, which is this January 1, 2024. You have to obtain the information that Stephen just went through and the appropriate photo ID, determine your due date, which is just 30 days from the date you formed it or at the end of 2024, and then file the form. Suggesting here, do it by certified mail. Although likely, it looks like it's going to be electronic filing, so you just have an electronic confirmation that the filing was done. The form, I think, is not yet out. Last time I looked. So.
Right, they're going to publish it.
Probably something like the FinCEN 114, which is the FBAR.
Right.
Here is a test for everybody, including your speaker here. This particular situation, we had a discretionary trust, a settlor, a trustee, which is going to be a corporation, and some beneficiaries. So, how would you approach it? We're using the protocol. The first thing would be identify the reporting entities. Settlor, if it's individual, that's not a reported entity, although information may be reported. Beneficiaries also, we're assuming, are individuals, so they're not entities. Discretionary trust itself, not an entity. We can't tell whether this is revocable or not, which has importance as what information has to be provided about the settlor. And we have the trustee. So the trustee is the reporting entity here, so the information about the trustee would be the owner of the trust company, if you will, would be required. Then we need to know the date it was formed, which is probably going to be before January 1, 2024. If go back on that. I'll add one more statement on that. Yeah, that the discretionary trust, if it just owns cash, that's not an entity. But if the trust own an entity, then we have another reporting entity, and then we have who's the beneficial owner. It's not the trust, but then you could look through the trust depending upon whether we have control by the beneficiaries or not, or control by the settlor, or if control is just by the trustee, then it would just be the trustee would be the beneficial owner of the company owned by the discretionary trust. All right, so the next one, it's a little more complex, but we see these. This would be a situation where we get husband and wife with a trust, special kind of trust that can own as S corporation. We have an S corporation that owns a Q sub, which is a disregard entity for tax purposes. And the QUIST, the trust qualified supplemental S trust, has a beneficiary, has a trustee. So then we start with, who are the entities? The trustee, likely, or it could be an individual. The S corporation would be one. And the Q sub, it's registered as a corporation, although it's disregarded for tax purposes, but it would be a separate entity. So it would be a reporting entity. So we have 2 or 3 reporting entities. And then we get into, well, who are the beneficial owners? Well, we've got 2 25% owners of the S corporation and a 50% owner, but the 50% owner is not an individual. But if the beneficiaries control the trust or the trustee controls the trust, that's not an individual. So who controls the trustee? So there may be somebody who controls the trustee is a controlling person, and the husband and wife, because they meet the 25%. So you can have 3 controlling persons, potentially 4, depending on what powers are given to the beneficiary. And you've got 3 reports, 2 of them dealing with the ownership by the husband and wife. Okay, next one. Here we're getting a little more complex here. We've got a irrevocable trust, an IGIT, known as an LLC, and the IGIT, this irrevocable trust, it's a defective trust, it's a grantor trust, has a non-voting interest in LLC. Then we have a revocable trust that has the voting interest. We've got beneficiaries, we've got trustees, and we got a protector, which could be an individual or a entity. So who are the reporting companies, entities here? Well, we've got the trustee again, potentially the protector, which are often companies, but are in the domestic situation is usually an individual. We've got the LLC, which is registered with the Secretary of State. Doesn't matter whether it's disregarded or not, although here it would have two owners. And then we get to, who are the beneficial owners of our reporting companies. We'll leave the trustee aside for the moment here, or for this purpose. So we got the LLC. So we got somebody who's got a non-voting interest, but likely value that meets the 25%, which would cause the trust to be an owner, but it's not an individual. So we have to find if there's somebody who controls the trust who's an individual. The settlors are, in this case, I guess it's the W, the Y, who may or may not have retained powers that would be enough to make that person a controlling person, or at least substantial influence. I made it a irrevocable trust as a grantor trust, so it's a possibility. You have to read the trust to figure out, what powers are retained. The trustee is not an individual, but individuals control the trust. So there's an individual up there. The protector is an individual. They would have powers to possibly remove the trustee, who's a controlling person. So that would make them a controlling person if that's an individual. The children as beneficiaries may or may not be controlling persons. And then going on the other side here, the voting interest, that would make the revocable trust. Whoever controls that would be the W. So W could be a controlling person for the LLC. And then you got to get the dates to figure out, when the reporting has to be done. Okay, so that's a complex situation. Next one.
I just wanted to go back for 1 second. Notice in this prior example with the S Corp, suppose there's a senior officer of this S Corp, they're a beneficial owner. Could be a family member, who knows?
We didn't put the officers in there. You're quite right.
Yeah, I know, but it's just, all these different variables.
Yes.
Bill, one thing on all of these charts that you're showing, where in green you have the real goal. Who are the real owners economically of these organizations? But yet you have these other people that may be officers, directors, trustees, and they all end up having to be reported as well. Unlike other areas of reporting, there is no exception if all the real ultimate owners are disclosed. These collateral people still have obligations, correct?
Yes.
Yep.
Multiple people who are beneficial owners. I think that's true.
And you're subject to the penalties.
Right. So, in example 4, shareholder discloses fully everything. That's what they want to know. And yet senior officers are still going to have to report, and so are board of directors.
Well, and this is an example where we do have the board of directors and the senior officers. So we end up, and shareholders. There's a C Corp. So the reporting entity is a C Corp. And then who are the beneficial owners? The board of directors, those are a bunch of presumably a bunch of individuals. So not clear that if any one of those persons controls the board or not. So those people may or may not be beneficial owners. The senior officers are by definition, and their name. So it's senior officers is a defined term in the regulations. And then the shareholders, you have to look at, who owns what. We got a 25% ownership there. We got people with options, convertible debt somewhere in here. So you end up with some of those shareholders, or all of them, being beneficial owners. So you have a lot of information that has to be collected in a simple structure here that we see all the time. Okay, next one. This is a limited partnership. Well, a limited partnership has to be, at least in California, I think in most states, has to be registered with the Secretary of State or a similar office. Well, that's a reporting entity. Then who controls it? Well, that's the general partner by definition. The limited partners, may or may not be substantial owners, because they could have a 25% interest. That would be typical. The general partner having a small interest and the limited partners having a bigger interest, but then there's more than one. So does any one of them have reached the 25% ownership interest? And do they, or anyone, I'm sure, does any one of the limited partners have substantial influence or substantial control over the management of a limited partnership? They probably shouldn't if they're trying to protect their limited liability. But again, you'd have to look at the partnership agreement and what in practice occurs to determine whether any of these limited partners or all of them are beneficial owners. And
it could include a profits interest.
Yeah, and you could have other interests as well in here. And you have to look at the dates and figure out when these reports have to be filed, and of course collect all the information once you've identified who the beneficial owners are. Okay, is there another one or not? I'm not sure. I think one more.
This is the next one, example 6, about who's actually, I guess, controlling the LLC. Maybe this is assuming that it's somewhere under 25% actual ownership interest. It's about who controls the LLC.
Yeah. Well, the manager is like, it's not kind of a senior officer, but it has the kind of the powers of a senior officer.
Mm-hmm.
And then the other members, they would have the value test, right? But there's more than one member, so it's whether any one member does or not. The proposed regulations talked about, kind of members or shareholders acting in concert or directors. So it seemed like that wasn't picked up in the final reg. So they're looking at kind of individual control or influence and not by group.
Well, there's still something about joint ownership. Well, that's maybe different. Yeah.
I'm not sure that's more the joint tenant. I think that's the joint tenancy, but I'm not sure.
Yeah, that's probably right. Indirect ownership.
Yeah, there's another next slide here. All right, this is more complex here. We've got a C Corp, it's got subsidiaries. You can see the ownership across the top there, 70%, 15%, 15%. And what we're trying to figure out here is we've got reporting entities, all these C corporations, obviously, but do we qualify for the exemption, which is this large operating company exemption? And so you look at each company individually, and we end up with the holding company C Corp. Should have made a different color here, but 3 million in gross receipts, which GR stands for. Got more than 20 employees. And then the regulations say, for purposes of the gross receipts test, if you have a consolidated return filed, you look at the whole group. So then we go down here and look at the gross receipts of the subsidiary companies, and we reach another 2 million, which gets us to 5 million. So what do we need? We need more than 5 million. I can't remember how it's more than 5.
Greater than 5 million, from what I see.
5 million. So we could have, these are round numbers. So maybe we got another dollar there somewhere that puts us over 5 million, which would make the C corporation then a reporting entity. Because you look over there, I got 0 for that one C in the corner. Now, what about the other companies? Each one of those can use the group to get to the more than 5 if we had an extra dollar here. So all of the subsidiaries would be, including the one that has 0, would have more than 5 if we put that extra 1 in there. But would they meet the more than 20 full-time employees? Well, the way the regulations are written, you look at the consolidated return to figure out if you meet the more than 20 employees, full-time employees. So the subsidiaries would not then be reporting entities. under this analysis. It's kind of strange that the gross receipts, you look at the whole return, but for the employees, you don't. At least that's the way you can clearly read the final regulations. Okay.
I'm just going to quickly cover what do they do with these reports. So it goes to FinCEN, and they're going to create a division of the Treasury Department, and they're going to create a giant, enormous database, probably going to cost 100 million or who knows how much to create this database, collecting, I think it's estimated over 30 million of these reports initially, and 5 million on average thereafter each year. And the information is private. It's only going to be disseminated to certain agencies. You can see them listed there in the small bullet points. Federal agencies engaged in national security, state and local enforcement agencies, the court has authorized the request, et cetera. As you can see, financial institutions with the consent of the reporting company, and also international legal entities that are requesting information about obviously money laundering and that kind of other kinds of crimes. So basically, it's supposed to be very confidential, and hopefully it won't get hacked, although that remains to be seen.
Examples of leaks, so I'm not.
Yeah.
Okay. And it's not clear what it's going to take to get a court order for state agencies to get access to this information.
Yeah,
I would have thought that the Franchise Tax Board, for example, would have been given access to this automatically.
Right.
And they're not.
Slide, actually. But also, it just went out of my mind. Geez, I'll come back to it in a second. But there's the next issue is, well, it's really supposed to be to get bad actors, money launderers and drug dealers and, you know, all Russian oligarchs who are concealing their assets, et cetera. But I don't see anything that would prevent the tax authorities, the IRS, and probably even the Franchise Tax Board from requesting information with respect to maybe, well, certainly for criminal tax issues, but why not even for non-criminal? That's kind of not clear, but why couldn't they go after, which certainly would help in audits for the IRS auditing high net worth individuals in ascertaining their related entities and related persons or intermediaries, et cetera. So this could be a real cause of concern that these beneficial ownership information statements, if they can create a database they can really utilize properly, could enable them to access a lot more tax delinquent issues. So this could be a concern, not just from a national security perspective, but a weapon for tax collection, possibly. You can see at the bottom there, potential for similar requests from state and local tax agencies, question mark. Okay, now we get into the penalties. So what's the penalties if you don't properly comply with these new rules, which are very broad in scope? Well, interestingly, the law uses the term, if you willfully provide or attempt to provide false or fraudulent beneficial ownership information, so including like false or fraudulent identifying photograph or document, or if you willfully fail to report complete or updated beneficial ownership information. So the term willful has been, of course, litigated in with respect to the foreign bank account report standards and other international information filing requirements. So there's some law on willfulness, and it's been interpreted to mean just being reckless, not necessarily intentional. So that could be an issue, even if you're not intentionally providing proper information. Okay, what are the penalties? So any person who violates the filing requirements? Yeah.
Back to the previous slide, there is a question. Yeah. On the second, willful to fail to report, The only persons required to report is the entity itself. So it seemed like the second one, failure to report complete or updated beneficial ownership. I don't think that would necessarily be the senior officers because the entity is the one that's required to report. The first one there would to provide false information. That would be somebody who is the beneficial owner who's giving a phony photograph or ownership document. So it's a little unclear on the second one, who's picked up. The entity, I guess, subject to criminal penalty, but there's not an individual you can put in jail or incarcerated under the second one, or you actually could fine them, but you can fine the entity. But anyway, it's a little unclear what that second one means.
Okay. Yeah, there are some, there are going to be FAQs issued. There are issues that have not been totally resolved yet, despite the fact that they spent over, I don't know, a year and a half and taken, who knows, 400 requests and questions and finally coming out with these regs. It's been a long time in the making. There's still issues that are not fully resolved. So with regard to the penalty, it's a civil penalty of $500 each day, not more than 10,000 or 2 years in prison or both. And any person who knowingly discloses or uses beneficial ownership information obtained through a report, fraudulently, a penalty of $500 per day, not more than 250,000 or 5 years in prison or both. And then there's a third penalty, which is while violating another law or as part of a pattern of any illegal activity involving more than $100,000 in a 12-month period, a fine of not more than $500,000, 10 years in prison, or both. So the most common one is the $500 per day, not more than 10,000, or 2 years in prison. Still, it's a pretty hefty penalty just for an innocuous oversight, let's say. Okay, I mentioned the safe harbor before, that if you have an incorrect or incomplete filing, that if you correct it within 90 days, they give you 90 days instead of the 30-day typical time period to correct, you will be immune from the penalties. So from what I see, it looks like the penalties could apply to an individual reporting company or even other entities who directly or indirectly provide false or fraudulent information. But this is one of those issues that is still not crystal clear. Like foreign trustees, do they have to provide information? And a company applicant, so are they liable to these penalties? Okay, then we have the code with respect to conspiracy to commit offense or to defraud the United States. So obviously this is something that one has to also be concerned about. And of course, this could be particularly sensitive to persons who are, let's say, senior officers of entities that are owned by, let's say, foreign investors who one may not be so sure about how clean the money is. Yeah. As a senior officer, you are a beneficial owner and possibly could be having some liability if the report isn't properly filed. It might mean that a lot of people will not want to be senior officers of entities where they're not sure about the veracity of the source of the funds. Okay, then there's some provisions about the Inspector General making investigations in case there's a cybersecurity breach, which is obviously going to be a cause of concern. And then there's a user complaint process that can be also available to talk about, ask for improving the system of accessing this information. And okay, so the main takeaways, Bill is going to discuss that.
Okay, here we have some slides suggesting having some points about planning for practitioners. There's no definite answers to these, but we'll go through and I'll give my take, and maybe my other co-panelists have some comments as well. The first point here is determining whether there's any obligation. I'm talking about the practitioner or their firm to notify existing clients. And this is a question I've been thinking about quite a bit and trying to figure out how to do this. I first thought, well, we'll look at the minute books, but then we're not really collecting minute books anymore. It's been a number of years. We sometimes have copies, electronic copies, occasionally physical copies, but very few the original minute books, original documents in them. So that's, I guess you could look at, what minute books you have, both copies and originals. And then who is an existing client? We have, I look at, my list of client numbers that I'm responsible for, over years, and we're in the thousands, through over, I guess, over 4,000 names. Most of them are either entities or individuals associated with entities, or entities that own other entities, that kind of thing. And we can look at who was billed in the last year. Not just the ones that haven't paid, but the ones that have paid as well, to get a list, which is something that's manageable. So, how do you approach this? Well, I'm thinking of including a notice. The FinCEN has a fact sheet that describes the law. I'm reluctant to do my own description, because if I leave out, one of the 23 exemptions and it might apply to somebody, or don't have a complete statement of the law in my description, then maybe I'm responsible, for not identifying the particular rule that applies to a particular client. So I'd like to send an official document. Secretary of State's likely to send documents as well when there's an annual renewal. But I feel more comfortable, putting it with my bills. Could do a separate filing, but then the bills only go to people who have actually, had work in the last month, or have a receivable from, some prior month. So that's not going to cover everybody for the first year. So I'm trying to working on a list of, who we billed in the last year, which we can take off our detailed financial statements and find out, who we've been billing for the last year, whatever that, we do a 12-month or do a little bit more in a year. So that's my kind of first take on that. If I don't think it's practical to do the complete, list of all prior clients. I mean, just think about if you got, send it out to 3,000 people and you get 1,000 phone calls, in a 2-week period, how are you going to do anything with it? We go back to the prior slide there. We've go back to 50. Yeah. So let's go to the third one here. Procedure for onboarding a new client. I think this is an easy one. We have the 30. If we get a new client, it's going to have an entity that's going to be involved. Then I would think that we'd want to get the information that Stephen went through as to the information that will be required, with respect to being a beneficial owner, potentially a beneficial owner of a reporting entity. I'm not so sure how you're going to get the copy of, passports or driver's license. Typically, with our foreign clients, we have been getting copies of passports, just so we know who they are. And not talking to somebody who's inappropriate, has inappropriate objectives that's not being disclosed. So we do, as a matter of our onboarding of these foreign clients, get copies of passports. Typically, we don't get a copy of a driver's license, for instance, or identification card of a domestic person. We just rely on referrals, or how did they get to us, and it's usually from an accountant or some other referral source.
Bill, what are you going to do with your, for example, Chinese clients, where culturally everything is held in the name of the oldest male son for the whole of the family?
Well, well, that's why it takes more than the 20 minutes to unravel what's going on.
And they won't tell you, is typically the case.
You have to, some people may be nominees, and the what you're talking about doesn't really fit our legal system, because they, even though somebody's holding the ownership, legally they can do whatever they want with it, but as a cultural or family matter, they're going to follow, what mom or dad says, depending upon
Yeah, well, there is one of the categories under substantial control is this catch-all, any kind of arrangement, understanding, agreement.
Yeah,
subsume that.
it would cover that. Sometimes it's a little hard with a new client to unravel what Howard's talking about, because they have to get a trust with you that the information, they're providing information that you're going to keep confidential, or they feel comfortable giving you that information. So that can present problems with with foreign clients on these nominee or nominee type situations. The one about procedures for identifying changes in filing notification, that's going to be a real problem. I think all you can do is tell the senior officers that if there's changes in any of this information about beneficial owners, that there's going to have to be a report filed within 30 days. I don't think you can check with your clients every 30 days to see what happened. I mean, sometimes you do know, but I've had many situations where I don't know that, the shares have been transferred or there's been new shareholders and this kind of thing. And an LLC, you can have a lot of changes going on if you've got an endemic situation. All right, next slide. 51. This is one that I'm thinking about, which is somewhat related to what Howard's talking about. What do you have? A situation where you have people who don't want to give you the information. And I mean, I think you have to document that you requested the information, and you file as best you can. And you may have to disclose that you request the information several times and have got no response. These do come up. Foreign trust companies often don't let you, go through, the ownership structures, and I've seen that where they think somehow the U.S. doesn't have any control over, what a foreign trust company does. But it could be end up with penalties on the reporting entities if they're U.S. entities, for sure. The next one is, who's responsible for doing all this? I'm talking about preparing the reports and filing the correction report. I think on the formation of new entities, the incorporating or organizing attorney should be responsible for that. In terms of the corrections and things like that, I think, again, it depends on who gets the information about the changes. The accountants are likely to start telling their clients about this particular set of final regulations. I don't think the organization of the entity that they're appropriate for them to get involved. I mean, they do get IRS employee ID numbers and things like that, but I think it's a little different. This is not really a tax filing. There's some tax concepts involved, but just it's really not really a tax filing. The true costs of compliance. This is talking about how do you present this to the client? I've tried this a couple of times under the proposed regulations where a client is called and they said, by the way, these regulations are coming down the pike and they're expected to be out by the end of the year, which in fact happened. We see in the preamble that these are supposed to take 20 minutes or something to get these reports done, gather information. And I've spent 30 minutes convincing the client that these regs are really real and this is what they're trying to do. And then what has to be reported and when and all that. And you can soak up, depends on how fast you talk and how much the client pushes back, but you can spend certainly 30 minutes to 40 minutes just letting the client know what the requirements are, and you haven't done anything yet.
And what's the blended rate they considered the preparers are going to be paid, Bill?
I don't remember what it was, $40 or something like that.
Yeah, it's some nominal sum.
Yeah, they were taking an internal number. You know, if the company did it itself, you know, if the company has that kind of staffing, it's probably the more than 20, you know, employees and more than 5 million.
I think what they're predicating that $85 price tag to complete this is based on the vast majority being very, very simplistic situations. You know, just one entity and one owner or two owners.
Yeah, on the two clients I talked to, I've already got you know, if I billed for it, it would be you know, $400 or $500 a time, just explaining what the rules are, what's going to happen. So, you know, we're not even close to those kinds of numbers. And it also assumes that you're going to delegate this to a lower tier employee, even within a professional firm. And I think that would be a little dangerous certainly at the beginning to delegate this kind of responsibility. If anything else, there's going to be a lot of oversight, which is going to, you know, add cost in itself. And within a company, I think it's a little dangerous too to, you know, for the senior officers just to, you know, have some lower tier person that's making whatever it is, the $20 to $30 an hour, which is what, 60,000 a year or so, to do this kind of work. So somehow you got to work with the cost of compliance to the client, figure out something. You'll have some problems with the accountants who will, you know, do it maybe for less. Because their billing rates are less, and I don't know what, you know, how they're going to put this together in terms of part of the overall, you know, year-end work they do, if you will, or annual work they do. Determine the impact on legal opinions. Well, if you're doing a merger and acquisition and there's potential penalties inside the reporting company that's the target, you want to know about it. So just another thing on the checklist. You have to go through, ask for copies of the reports, and do some due diligence that the reports have been done properly. I think that what's the next 60?
Yeah. Okay. I'll wrap up here in like.
Yeah. Where are we going?
We have very little time, and we have maybe 3 Q&A we want to perhaps look at. So there's still 2 sets of regs regarding the beneficial ownership information matter that need to be issued. Most of them are, one set is about protocol, and the other is about setting up the whole database system. And the way the IRS, I'm sorry, the FinCEN is reaching out to all the Secretary of States and the states, and that's how probably you're going to get notified. Most people of the new law, Secretary of States will probably be notifying every time you annually renew your registration or what have you. This is how most people probably learn about the new law. This law, of course, only is applicable to beneficial owners of entities or company applicants. But there have been legislation just passed in the House, which would apply to all types of service providers who are maybe assisting persons involved in money laundering potentially, or what have you. And obviously the government wants to catch these people as well. And so this could apply to attorneys and accountants and trust companies, you name it. And so there is this so-called Enablers Act that was passed on slide 53 in the House, and it on slide 54. It was very broad, as you will see on slide 55. All the types of people it originally applied to, which is like everybody you could imagine. But it's been now reduced on slide 56 to 3 basic groups: trust and company, those companies that provide trust and company services, third-party payment services, and certain legal and accounting services. But the law still leaves it up to FinCEN how to interpret this. And so it's still very possible, like investment advisors might end up being added back. It remains to be seen what, if anything, will develop, because obviously it's somewhat political issue also. we can see that the ABA and also the California Lawyers Association have objected to this Enablers Act because it would conflict with the attorney-client privilege, confidentiality, to have to, submit suspicious activity reports about your clients if you suspect the source of their funds are not clean. And so that there is some case law on this, and the IRS has an Internal Revenue Manual with respect to Form 8300, which is also under the Bank Secrecy Act, where you have to report whether you have $10,000 of cash transactions, where the courts have held no. Attorney-client privilege does not protect you from having to reveal the identity and the amounts involved, as long as they're not too interrelated to the so-called confidential information. There is a special exemption, which is actually there's no case on it that's ever applied it. We're in special circumstances. Attorney-client privilege might apply. That's where it's like it's the so-called last link doctrine, where it's the last link in self-incriminating yourself if you were to file the 8300, Form 8300. There's also been recent legislation that hasn't passed where they wanted to go after the Russian and oligarchs and seize their assets, but this may come to fruition depending on how things play out. And you can see on slide 60 that they would not only, the forfeiture laws would not only apply to the actual proceeds of ill-gotten gains, but any assets that were used to facilitate these investments. So they're broadening the scope of the forfeiture laws. They would apply racketeering laws to them. They would extend the statute of limitations from 5 to 10 years. All of this could be very significant to a lot of persons or anybody assisting in those persons. So they're expanding these anti-money laundering laws and asset forfeiture laws. So clients may need to properly screen for assets in the future because of these potential significantly increased sanctions. Then on slide 62, it talks about the EU shell company tax directive, and basically want to close loopholes for shell companies being used in the EU to take advantage of tax laws. And you can see they're basically passive investment types of shell companies, and there's a rebuttable presumption if you fall under the 3 tests to determine whether you're a shell company on slide 63. And then on slide 64, there's 3 tests to determine how you can get out of that rebuttable presumption, being a shell company. Yes, Bill.
Slides are not moving forward.
Oh, I'm sorry. Yes, my fault. So here we have this is the U.S. Enablers Act, and it's all discussed here on slide 63, 54, 55. And this is who it originally all applied to, very broad. It was then whittled down to 3 categories in the actual House passed bill a few months ago. But the FinCEN still has very broad authority, as I said, to determine really who's going to be falling within the Enablers Act, should the Senate pass it. And it's part of the defense appropriation bill. So it's the NDAA. So there's a higher chance than one might think that it will be passed in some form. It remains to be seen. But then, as I mentioned, the ABA and the California Lawyers Association have protested because if this law were to be enacted, it would be conflicting with the attorney-client confidentiality and privilege rules. But as I mentioned, the IRS and case law has not been very favorable in arguing attorney-client privilege insofar as having to divulge the identity and the persons and the amounts involved. Then there's the forfeiture legislation, which would increase sanctions and anybody involved with those sanctions. So this could be coming in the near future, extending statute of limitations and racketeering laws to those type of situations. So you need to watch out for that and screen clients if that were to actually be passed in the near future. And then we have the EU shell company tax directive, which would be of interest to anybody investing in the EU. And this is also covering enablers also. And, you know, there's a rebuttable presumption if you meet these three tests on slide 63, basically passive type shell companies. And then on slide 64, how you can get out of the rebuttable presumption if you have actually some physical presence and meet some other standards on. And then 65, what the tax consequences are is you lose the benefit you're subject to of the treaties and you're subject to withholding tax. And there's even on slide 5% penalty here on top of slide 66. It does not apply to non-EU shell companies. So if you're in Switzerland, it doesn't apply. But now the EU has come out, or the EU Council has come out with another Enablers Act just in the last couple of months, July 6, 2022, which will go after non-EU countries that are using shell companies to invest into the EU, and also to prevent aggressive tax planning. It sounds like they're going after the big four accounting firms and other firms that are doing, quote, aggressive tax planning and wanting to force them to, do dedicated due diligence, follow dedicated due diligence procedures, possibly even force all these enablers to register in order to do business in the EU. Very severe rules and the code of conduct that could apply to all potential enablers, mostly lawyers and accountants, who are facilitating aggressive tax planning, quote unquote. So these are things that might be in the near future in the EU, and what happens to the EU eventually tends to come to the US, although sometimes it takes a long time. So that's in the children.
We have a few questions here.
Yeah, let me go to here, Q&A.
Jonathan, it says for the 25% test, I think, for beneficial ownership, is there a concept of constructive imputed ownership? I mean, Howard, you covered that, I think, right?
Yeah, imputed ownership clearly, and constructive ownership is a matter of state law. Do you own the asset? And so again, this is where it may be dicey, but if in doubt, report. And the second one is, is it subject to disclosure under Public Records Acts or FOIA request? The answer is absolutely not subject to public disclosure.
Well, if you're talking about the 25% ownership interest test, I would say there is a broad catch-all rule there. If you control other people's shares somehow, you have an intermediary or nominee kind of situation, arrangement, understanding, then yeah, that's imputed, but not per se. I don't think there's constructive ownership per se under 267 necessarily.
Well, constructive ownership would be somebody steals from me, somehow cheated me out of the shares, and they're now holding them, and I'm accusing them and asking the court to impose a constructive trust to return them to me. The person who has them would be a nominal owner, at least at the time they still own them. So they would have to disclose it. If I'm the one making the claim saying Joe is constructively holding my shares, you sure better disclose.
I mean,
he's saying that they are my shares.
Yeah, I mean, I think the point is sorry, Bill, go ahead.
I guess as a look through, you could have constructive ownership in a sense of, you know, your 10-year-old child owns the shares, and you know the parents really are controlling the share. It's kind of a family ownership, but it's not based on a specific family ownership rule, but more the actual facts. And there is
right. So the fact that your sibling owns the shares, I don't think is necessarily imputed to you, but it does say here if you control the owner 25% ownership interest through any other contract, arrangement, understanding, relationship, or otherwise. So it's pretty broad, but you know, it's kind of more like along the line of a nominee or intermediary, I think, arrangement. They have, as we discussed, the look through the trust arrangements. There's very broad attribution rules there. Even a protector could be deemed to, you could be owning the shares of a controlling.
Looking through trust and things like all constructive ownership for tax purposes under like say two is that a federal statute? I guess it is.
Yeah. So the control of shares is kind of vague. Oh, we have another question.
I think that's all the questions we have. Any closing comments, Stephen?
Well, this is going to apply to a lot of people and some of the structures are going to be quite complicated to figure out all of the beneficial owners that need to be reported. And if you fail to report some senior officer, well, then you could be subject to the penalties, and even the minimum penalty is $10,000. It's interesting that it's the penalty can be $500 per day or up to $10,000 or 2 years in jail.
I think
match.
Howard, quickly, 30 seconds. Any last comments?
Sure. This whole concept of disclosure, and you overlap that with this enabler notion. About a decade ago, there was a congressional report on quotes enablers, and they were talking about the large accounting firms and large law firms. And so, clearly us professionals are in the crosshairs of all these reporting. And Stephen quickly jumped over the Title 18 conspiracy law. But, that's something that could be applied to lawyers who help their clients circumvent this. Bear in mind that all this is under FinCEN, which is not under the IRS. And although FinCEN may be able to delegate part of this to the IRS, I doubt it's going to come under the 80,000 new employee rule. So it's going to be real interesting to see what happens with how they're going to get the money for all this.
Tonight's election may result in a few less IRS agents. I think almost all the Republican candidates are running against expanding the IRS's workforce. But I think they'll certainly get the computers, which will be useful for them. I guess my only final comment is plan for your existing reporting entities that you have, as clients or former clients, and just decide what to do and figure out, who to notify and what's practical in terms of servicing, the hundreds, if not thousands, of prior entities that you've formed, or your entity or your firm has formed. With that, let me thank Stephen and Howard and the Beverly Hills Bar and the business law section and the tax section for sponsoring today's program. Have a good day.